Let's talk about the two ways to start the patent process for getting a utility patent and why one of these is going to be the preferred method for startups. At least that's how I almost always start with startups. So the first one, and this is the first line here, you can start with what is called a non-provisional patent application. So here, you have an idea, you're going to develop it, you decide the time is right to file your non-provisional patent application. And this is the really formal patent application that has to have the black and white line drawings, it has to have the certain sections, and this is typically going to be attorney drafted. You really, if you're serious about it, you should have an attorney draft your non-provisional patent application. Otherwise, you're going to have a lot of difficulty. The non-provisional has to have the claims section. It's going to have the detailed description, all that kind of stuff. So you draft and file your non-provisional patent application, and then it's going to wait in line for 1 to 3 years before examination begins. And why is this? Why is it taking 1 to 3 years? Well, it's the government. The government's kind of behind. You just sort of wait in line until examination begins. And it depends on the type of technology. So when you file your patent application, it gets sent to what are called art units. And so some art units are really, really busy. So for instance, like in things like AI and computers, even though they staff those really heavily, those can get really, really backlogged because there's a lot of people filing patent applications in these spaces. And so those kind of art units, those will probably take 3 years, whereas other things that aren't as invented in as commonly, or there's not as many patent applications filed, it may only take a year to get to examination. Just totally depends on the examiner it gets assigned to, the art unit, all those things. But a lot of people are surprised that it takes 1 to 3 years to get to examination. That's once the examiner picks it up. What they're going to do is do a prior art search, determine whether what is claimed is new and non-obvious of the prior art, and then they're going to formalize the rejections, which is, I'd say in 95% of the cases, there are going to be rejections. It's a natural part of the patent process. So the examiner is going to formalize those rejections into what is called an office action and send that to you. And then you have a period of time where you're going to draft a response to that office action. So you can argue against rejections, you can amend the claims, you can do a little bit of both. And this starts sort of the back and forth with the examiner. A great way to think about the examination process, it's just like any sort of haggling. Like if you go out, you go to a market or something, you go to a flea market and you're haggling over prices. It's the same thing, right? So this is a natural negotiation. And just like haggling, the benefit is that you're going to get the best patent protection possible. So it's important to understand patents are not just a binary thing where you have a patent or you don't. You can really have broad patents that cover a lot of different variations, or you can have patents that are so narrow and so specific that they're effectively worthless that people could easily design around them.